everybody. Happy Friday. I hope people are happy. It's really, really, really warm, as you know. I'm not telling you anything new. A little humid out there, but it is definitely summer now. Happy 4th of July. I know this is like the second Friday, not the first Friday, but hopefully you had a nice holiday. Things are pretty nice outside with the weather, but for some of these crazy thunderstorms. So today we're going to be talking about clubs. I have to do my little announcements first. First of all, thanks so much for coming on this beautiful day. You know the usual. This is general informational purposes only. I can't see anymore, but you do not and cannot form the attorney-client relationship over this discussion. The information exchanged does not constitute legal advice. To obtain legal advice, you have to enter in a retainer agreement with a lawyer. Nothing will be kept confidential in terms of the chat, etc. But if you do have questions in the chat, please go ahead and put them in the chat. This is a hot topic. The one thing I want to say, though, before we get into it, is that we're not looking to start problems by having this discussion. So hopefully whoever's on the call today, you don't run out into your association and go, oh my gosh, we need to reinvent the entire community and ban all the clubs and everyone, no pickleball and no mahjong, and you need all sign waivers and do all those other crazy things. It's a discussion. So it's really an effort to highlight the issues. Okay, highlight the issues because many associations turn a blind eye to the clubs. They don't really deal with them appropriately. And they really should be, at least at a minimum, thinking about them. So we'll start. You know what? We don't have a dog of the day today. Everyone's going to have to go out and go to their local shelter and adopt a dog because we're shorthanded in the dog department for some reason. We have a cat, though. We do have a cat. There's the cat. That's Ty. That is Mohammed Salyani's cat. Very nice looking cat there. Mohammed, I don't know if Mohammed's on the call with us today. For those of you who don't know, Mohammed is the partner in charge of Wilkin and Gutton Plans Community Association auditing practice. So he's a CPA. Great job, Mohammed. And if you're on the call, welcome to shoot a comment in. Thanks for sending in Ty's picture. Beautiful cat. And we'll just roll right into it. So clubs, what are they? So many of us on the call are in active adult communities, but clubs are usually more prevalent in active adult communities, but saying that many non-active adult communities have clubs as well. So the clubs are where most associations, at least pre-Facebook, where we all started, we just sit on our phone at home on the sofa and look at each other doing our activities, but actually where people do activities in the real world rather than on their cell phones. So things like the card club, the travel club, some places have the Helping Hands Club, golf club, pickleball clubs, all those types of things. They're all wonderful things, especially in active adult communities, because they do provide a social network and they do provide a social outlet. And they keep people active in the community, and you make friends there. And you actually make real friends, not just cyber friends, where you're sending each other chatbots. They're a great thing. They're a wonderful thing. What associations, though, need to do is define the relationship between the club and the association. So is it going to be an association-sponsored club? Okay, the Oak Manor Pickleball Club? Or is it going to be an independent club? Something perhaps the Ancient Order of the Hibernians for Hillsborough Township that just so happens to perhaps use the association's ballroom to meet. Or the association members, the Hibernians, actually meet in the association's facility, but it's not an association or a club of the association. Right? So you want to define that. How do you define it? The associations should, either the manager and or a board member should meet with these clubs who are using the association and figure out exactly what the association's club intends to do. If it's an association club, if it's an outside club, what they intend to do on the association property and who they intend to bring. Is it going to be just association members, or is it going to be association members and third parties from outside? Because that makes a difference. One thing, this is an aside, this is a topic perhaps for a whole separate seminar, is be careful when you have outsiders using association common facilities. because although the associations are subject to the Fair Housing Act with respect to compliance for handicapped accessibility, et cetera, they're generally not considered places of public accommodation, right? Because they're private amenities. But some associations, through their actions, can turn a clubhouse, for example, into a public facility by the way they use it. If they're inviting the public all the time, if they're having public forums, public speakers, the public are using it, the public are paying for services or use of the gym, things like that. I cringe a little bit when I say that. So be very careful. All right. So the first part is define the relationship between the association and the club. Association sponsored clubs. So association sponsored clubs will generally have the association's name, in the name of the club, right? So the Oak Manor Mahjong Club, the Oak Manor Travel Club, things like that. If it's an independent club, you should discourage using the association's name in the name of the club, right? And that may be a hard thing to do. The reason I say that, though, is when people hear the Evergreen Mahjong Club, they tend to think that it's an association-sponsored club. It's actually sponsored by the Evergreen Association, right? And if people are led to believe that the association is sponsoring a club, they will have expectations, right? So it's managing expectations. And usually the first expectation is somebody's watching the money. And if they believe it's an association club, and they believe the association's watching the money, and something happens with the money, who is the first person they're going to turn to when the money isn't there, or the money is spent in a way that's improper? They're going to turn to the association's management company. They're going to turn to the association's board and say, wait a second, we have a travel club here, and I put a deposit down of $1,500 for our European river cruise, and it disappeared. I want my $1,500 back. And so be careful about that, because perception will come into this. So I would say the safest advice in terms of distinguishing between an association-sponsored club and an independent club is if it's an independent club, again, Ancient Order of Hibernians, or the North Brunswick Italian American Club, it should not include the Hearthwood at North Brunswick Italian American Club, right? It should just be the North Brunswick Italian American Club, and perhaps the Italian American Club uses Hearthwood at North Brunswick's clubhouse for various events. So be careful. Perception does mean things. When we get into independent clubs, if you have an independent club, what does independent mean? So independent clubs generally have their own set of bylaws, right? They have a certificate of incorporation. They're more formal. They're distinct from the association. They have a separate tax ID, right? So they have a separate tax ID. They are not operating under the association's tax ID, right? There's somebody looking to come in there. So they're not operating under the association's tax ID. There are instances out there where clubs actually are operating under the association's tax ID without telling the board or without telling the association's manager, which is going to cause you perhaps to get jammed up on a tax basis going forward. So you have to be careful about that. So the certificate of incorporation for independent, bylaws, they should have their own separate insurance, right? And if they have their own separate insurance, an independent club, generally speaking, if they are conducting affairs or events on the association's property, the association should require that independent club to add the association as an additional insured for that event. Does that make sense? So the Italian American Club of North Brunswick is using Hearthwood's clubhouse. They should have their own insurance, and that independent club should be adding the association with respect to that event. The other thing that people need to think about, whether it's independent clubs or association-sponsored clubs, is are they using independent contractors? Who are they bringing onto the site? Are they using independent contractors? Are there employees? Is there liquor being served or sold at their events? What do we do in terms of a possible personal injury claim, because I know there are a number of Four Seasons. Hi, Colleen. I saw somebody else. I saw there's Brenda. Hey, Brenda. And hello, everybody. So Four Seasons had a case years and years ago, decades ago now, where a DJ had a wire running across the dance floor area, and somebody who attended one of their functions tripped and fell and got injured pretty severely, and the association gets sued because the DJ did not have their own insurance, and this was no fault of the board. But what happens, what the tension is with using clubs and club-sponsored functions is it's hard to find a DJ or an aerobics instructor or perhaps a personal coach type person to come in and speak or do a DJ, do a party, or do aerobics training that makes enough money to justify the insurance expense. So the board has to balance the risk versus the benefit. And many boards make the choice like, hey, if we're going to have events and we're going to have a DJ, and the DJ is saying we can't find a DJ who has insurance, full insurance like we'd like, are we going to be prepared to take that hit if somebody does get hurt? And will it hit the association's insurance? And will that claim be covered? In the Four Seasons case, the association's insurance carrier wound up covering it, which that's what that policy is there for, right? So you have to be careful when you're weighing the risk and benefits. You don't want to be too risk averse, because then you'll have no activities, right? You'll say, hey, we can't do aerobics here. You know, we can't play pickleball here. We can't have a dance. We can't have a DJ. We can't have a band. So it's a balance. You want to have insurance. You want to have, if you're going to have independent clubs, activities, you want to have all the bells and whistles in terms of bylaws, governance, financial responsibility. But sometimes that's not possible. So that independent clubs, like I said, separate documents, et cetera, et cetera. Legal issues. What were some of the legal issues? I touched on it before. The association's property is private property unless the association makes it otherwise by inviting the public on. So that can happen. What about constitutional issues? So constitutional issues do come up sometimes in the club context, where they come up generally with respect to political organizations and or religious organizations, right? So if you're going to have clubs that use the association's facilities, it becomes very difficult, if not impossible or illegal, to discriminate based on what the club is doing, right? So you couldn't say to the Italian American club, no, you can't have your party here, but you have the Hibernians, the ancient order of the Hibernians, come in and say, yeah, you can have your club because our lawyer's Fran McGovern and we like Irish dudes. No. Well, we love Italian people just as much. So people get jammed up sometimes. That's just a funny example, but people get jammed up sometimes with respect to political organizations, basically protected class status, race, creed, color, national origin, things like that. So if you have to be very cautious if you're going to say to a group, no, you can't come here. This comes up sometimes when, say, for example, the men's club or the women's club says, we're going to have the Republican candidate for blah, blah, blah town come in. We're going to sponsor that person, come in and meet. And the board says, that's fine. And then the other club says, hey, we're going to have the Democratic candidate come in and speak. And the board goes, no way, we're not letting the Democrat come in here and speak. You're going to have a problem there, right? Because you get into speech issues, you get into various, the right to organize, the right to have meetings, right? So you have to be cautious. Those things tend to sneak up on associations by surprise, but unfortunately, there are some associations that actually pursue that type of thing. I have run into it several times with respect to religious organizations. So believe it or not, I've had associations where they actually hold religious services in their clubhouse. Now, there are associations that say no religious clubs can use our common facility. I don't believe that's proper. But what it can't be is that you say to one religious organization, yes, we're fine with you, but the other religious organization, no, you can't have your event here. It has to be fair treatment. So be careful of employees. Are they employees? Are they 1099? If they're being treated like employees, they should be treated like employees for legal purposes, which means taxes, insurance, etc. Be careful of liquor issues, right, on the legal side. Be careful of charging money for things like showing movies, right? So there are associations, the men's club or the women's club will have a movie night and charge for tickets, but none of them get the license for showing that movie to the public, right? And they're making money from it. You should be paying your copyright fee for that. If the association's club doesn't do that, the association may be liable for that, the charge from ASCAP or whoever the organization is that does the licensing for whether it's music, movies, or other things. So be careful there. When we get on to financial issues, this is the big issue, right? If it's an association-sponsored club, the clubs must be responsible financial reporting to the association. And we mentioned Muhammad earlier with his cat tie. Muhammad has an article out there on this topic. The association-sponsored clubs financials should be incorporated in the association's financials. At least that's what Wilkin and Guttenplan's position is, and I agree with it. And you know, those of you who are CPAs on the call, you'll have to talk to your association auditor about that. We have to be careful. So a question came up from Colleen, which is a good question. I actually have it here in my notes. You anticipated it. She said, "What about bingo? What about bingo?" And it doesn't just go for bingo, but it goes for gambling as well. Any type of gambling. What the state calls those things is games of chance. So games of chance, you need a license and a permit for those types of things. I have had associations set up wholly independent clubs, entities with bylaws, etc., just for the purposes of bingo. Just for the purposes of bingo. There's a place in Hamilton Township where I did that because the association, even though it was an age-restricted community, had many younger people living there, right? They had just hit 55. And under the games of chance, Attorney General's rules and regulation, the average age of the community residents didn't qualify for bingo as older persons. They were too young across the board. But I would say it's probably a pretty good idea if you're running bingo operations, 50-50 games of chance, to have a separately independent organization. I think it's probably the cleanest way to handle it. But whether it's independent or it's an association-sponsored organization, the association should be making sure that the proper documentation and licensing is through the Attorney General's office. Actually, I don't know if it's the Attorney General's office. It may be the division, the DCA, Department of Community Affairs. I don't know off the top of my head. I haven't looked at that in a little bit. So games of chance, Colleen raised a good point there. That goes along with alcohol, proper licensing, etc. So when we get into financial issues, reporting. So it's association sponsored. It should be reported on the association's financials. The organizations should be reporting to the board on a regular basis. If the association is handling their own money, the association should be darn sure that if it's a sponsored organization, that money is held in safekeeping. What things get a little dicey at times when one person, a single individual, is responsible for keeping the money, right? That's when things tend to disappear. There's no financial controls, again, for the CPAs and the other accountants in the audience. There are no financial controls. Oftentimes, people are just winging it. There's money put here, there, and everywhere, and then the money disappears, and everyone says, "Why did the board not protect our money?" Well, the board didn't even know about the money being collected, right? Board had no idea what was going on. And that's not unusual. I'm not casting stones at the board. This happens often. So you just have to be careful. So you also have to be careful about tax liability. So the revenue of a club, whether it's independent or which the association is not as concerned with, but if it's an association-sponsored club, the revenue that a club generates may be taxable. So you have to be careful and speak to your association auditor about that. There also may be sales tax implications. So if an association is buying items, an association sponsored club is buying items through their club, the association will want to make sure they're paying proper sales tax. Otherwise, a sales tax audit could come in and you wind up with a sales and use tax audit and a penalty and payment of back taxes if the sales tax was not paid. Association should not turn a blind eye to association club activities because ultimately the association will be held financially responsible if the association is not doing the right thing. So you have to be very careful about that. The other thing about finances is people get confused with respect to for-profit, right? For-profit, not-for-profit, charitable. For-profit, not-for-profit, charitable. And there are a lot of people who run around saying to people, hey, we're collecting money, we're selling this and that, chances 50-50, and it's all going to charity. Maybe. Is it a charitable contribution? Can those people who donate money to an association club actually write it off on their taxes? If it comes about that a member donates to what they believe to be an association club that is charitable, and they find out that it's actually not charitable and it's not tax deductible, what is the implication for the association? What's the implication for the club and the taxpayer? So be very careful with respect to clubs that are saying they're charitable, because they may have charitable intent, but that might not mean that the IRS feels the same way and that people should be deducting that from their taxes. So you got to be very careful about what's going on with clubs and how they're describing their activities. Insurance issues. Very careful in terms of off-site activities. I'm sure, since I'm preaching to the choir, every person on the call today has their insurance professional come in at a minimum once a year, and they do it for free, and evaluate what you're doing and who's doing what to who and what coverages you have. Especially with respect to clubs, very, very dangerous in terms of whether or not you're covered. If an association club is doing off-site activities, the association's general insurance policy, whether it's liability, fidelity, or D&O, may not cover, right? Debbie Pasquarello has done presentations on this. I think I've actually done presentations with Debbie on this. Off-site activities can be very risky. Bus trips to Manhattan, travel clubs to Europe. Anytime someone gets on a plane, probably not covered by the association's insurance. Anytime someone gets on a boat, probably not covered by the association's insurance. What should be happening, I'm not trying to discourage those activities, but what I'm saying is that if the association's clubs are going to sponsor those types of activities, they should meet with the association's insurance professionals and make sure that they get either an endorsement or a separate policy to cover those types of activities, right? Because travel clubs may handle a lot of money. Bad things may happen. Someone, God forbid, dies on a trip. A bus crashes on the turnpike, right? What happens? Who's getting hit for that? Is it the association's insurance policy? God forbid, the individual people who are sponsoring the travel club, right? You don't want that to happen. So you got to be very careful in terms of insurance coverages with respect to the liability, the D&O. You say, hey, Fran, why D&O with respect to clubs? Well, what if there's a club organization and someone says the club chairman or chairwoman slandered me? She said bad things about me and the way I play pickleball. I have an awesome backhand, and she said my backhand stinks. No, that's not slander to begin with. But the claim, you would want that covered by D&O, right? You want the attorney fees covered for the defense. And if you don't have proper coverage for your association clubs, you're going to have a problem. The evolving population issues, getting back to pickleball for a second. So evolving population issues, pickleball is like the sport that has taken the country by storm. And this relates to insurance because I have even friends in my own neighborhood who say, "Oh, Fran, we're we're engaged in this pickleball league and we're going over to Monroe Township and we're going to play these guys there and these ladies over here. And many times the association's blanket insurance policies will exclude coverage for organized sports activities, right? So if the Brandon Farms pickleball, savages are playing the the Four Seasons ferocious animals in pickleball, and there's a circuit that's made up, oftentimes the association's insurance will exclude coverage for organized sports activities like that. So you need to ask your insurance professionals what's happening, right? If the if Brandon Farms pickleball club is playing over at Four Seasons and someone gets hurt or someone has a heart attack on the court, God forbid, and there's a claim, whose insurance covers? Does the association's insurance covers? Does the unit owner's own health insurance cover? Is there a claim back? Is there a claim back against the club itself, et cetera? So you have to be careful. In terms of probably the biggest risk I've seen in terms of clubs is I guess they used to be called helping hands clubs. Anyone hear of helping hands clubs? So that's in associations, especially active adult communities, where they have helping hands clubs, and they are either checking on elderly people. I guess they used to be called shut-ins, checking on shut-ins, or driving people who are unable to drive to supermarkets and things like that. That is a big gaping hole for potential liability. They're wonderful clubs, right, in terms of the intent, but the exposure can be great. So you have to be very careful. You have to make sure that the association's policy would cover those types of activities. If the association is not going to be able to obtain insurance for a type of activity, the association still wants to do the activity, at a minimum, the association should have things like waivers, like saying the association is not sponsoring this club. You can have an independent club, but it's not sponsoring the club. Trying to get separate freestanding insurance if they can. Similar to the helping hands types of club, I had an association one time. They wanted to make something like the Helping Hands Club, but I forget what the name of it, but it was a club to collect and distribute durable medical equipment, right? And as you can imagine, my hair like stood up this high on the top of my head, right? And I said, what are you talking about? When they said, well, Fran, we have a lot of people who have medical procedures because we're all getting older, and people rent commodes and they rent scooters and they rent motorized wheelchairs and crutches and all those things like that. And half the population in our community has durable medical equipment laying around in their garage. And these durable medical equipment companies charge crazy prices for this stuff. And if we just kind of collected it and kept it in our garage, the association's garage somewhere, it would be great because we could lend out the crutches, we could lend out the walkers. And when Bob has had his hip replaced and he's off the walker, somebody else can use that walker at another time. Huge liability there, right? And I advised strongly against it, and the association wound up backing down and not sponsoring that club. It was a great idea from a human standpoint, but from a liability standpoint, you can just imagine what would go on if there was a walker that wasn't working right, and Bob falls a week after getting his new hip and has to have the new hip redone. Really risky. And obviously, we've been through COVID and we've talked, I know Brenda has torn her hair out over this, all about transmitting diseases or infections with various things, equipment, areas, et cetera, like that. So it became even a bigger deal in COVID. You don't want medical equipment shared with various people, obviously. So you have to be really careful, I think, is the touchstone, without crushing activities, without discouraging people. So it's a balance between chilling all the activities and being a bummer. The lawyer is always the killjoy. Anytime an association wants to do something, they call me and I say, no, you can't do that. And that's not a lawyer's job. Our job is to try to help the association balance the benefit with the risk of doing it, right? So that's what we really try to do, and that's often overlooked in the club context. More often than not, we don't get the phone call until, Bob has fallen and broken his hip. And he says, wait a second, the Helping Hands Club was the one who lent me this walker and the handle on it was loose. Or the Helping Hands Club drives, Kathy to Costco, and there's an accident in front of Costco, and Kathy and whoever was driving her get injured in that car accident on the way to Costco that the Helping Hands person was driving, right? The road to hell is paved with good intentions. So we have to be very careful about that. The clubs are a wonderful thing, but it's all about balance. And more often than not, I know I'm talking about a lot of physical stuff, but more often than not, the real questions come about with respect to finances. Who's holding the money? Where's the money go? Why are they spending it the way they are spending it? That doesn't seem to be in line with the club's charter. Why are we trying to support a political candidate when this is the bowling club, right? Why, right? That's our money. We're talking about bowling. The money was supposed to be for signing up at the bowling lanes and buying shirts and trophies. What's the problem, Fran? So let me see. We have a number of chats in there. Mike, do you see the chat up there yet?
I see all the questions, but I think.
Oh, by the way, sorry, Mike, there's an oversight. So Al D'Amato suggested today's questions from Leisure Village. Thanks, Al, by the way. Al has the first question there, Mike. I don't know if you see.
Yeah, it says almost every club here has our name in the title, but they're not associated with the association. I don't know if you want to touch on that.
Yeah, so I'll talk about that. So if the association is going to undertake putting more structure, we'll say, in the clubs and distinguishing between association-sponsored clubs and independent clubs, it should go down that road, but it should go down that road gradually and gently. Otherwise, you create a civil war and you have people walking away from activities. So, best practices would be, if it's an association-sponsored club, it would have the association's name in the name of the club. But if it's not an association-sponsored club, it would not, because it leads people to believe that it is an association-sponsored club. Go ahead, Mike.
And then what about a club having a function and the guests are paying to attend the event?
So I don't think there's anything wrong with paying to attend the event. You would have to run that by the association's auditor, and it would often depend too on who's paying, right? So again, I'm not an accountant, but member income is generally not taxable. This is just rule of thumb. It may be different in terms of what you're paying for, but non-member income generally is taxable. You have to be very careful about that. And again, I know we have accountants on the call, and they could probably add all kinds of feedback to that.
The next question, Fran, says, if a sole proprietor, such as a DJ or aerobics instructor, has liability insurance, do they also need a workers' comp policy to provide services in the clubhouse or other facility?
So I think an insurance professional would answer this as yes. I think in the real world, most DJs and aerobics instructors would say no. What's the risk? If there is a risk in terms of an injury like that, it may hit the association's workers' comp policy. So I have had a conversation with Debbie Pasquarello about that. And again, I'm not, Debbie's awesome. She's obviously not the only insurance professional in the industry. There are many other good ones. It's just that I know I've had conversations with Debbie about this stuff. She would probably say that if there was a workers' comp type issue or injury, and there was no workers' comp insurance with the vendor, it may very well hit the association's policy. So I think that's the risk.
All right, the next few questions pertain to bingo and licenses, but you already spoke on the game of chance. So
yeah, okay, I'll just hit it real. So bingo, yes, you need a license. 50-50, you need a license. What about luncheons at various restaurants like Romeo's and Juliet's? So what about, well, we'll get to bocce courts in a second. So luncheons, if it's a club-sponsored luncheon, you just want to make sure that you're, if it's an association-sponsored club, that it's going to be covered by insurance if someone falls or chokes or gets poisoned at the luncheon, right? So you got to just make sure you have coverage there.
And then Fran, my understanding has always been the directors and officers policies typically cover committees and individuals on those committees, working in the committees and making decisions, but not the clubs. Whereas, liability insurance would possibly cover both of them, but the directors and officers under the committees. I don't know if you touched on that earlier.
Yeah, I touched on it a little bit earlier. My impression was, and again, I'm not an insurance professional either, but my impression is that typically they would respond even on a D&O claim. But again, run that by your insurance professional, because a lot of that depends on what policy is out there. And again, those insurance comments by Mike and me apply to association sponsored clubs, right? Not an independent club. What about bocce tournaments? So like the pickleball, so if it's an in-house tournament with an association sponsored club structure, in theory, you should be covered. You have to make sure, though, even if it's an in-house tournament or an in-house league, that there is not an exclusion in your package policy for organized sports. Because I know that there is organized sports exclusion language in some association policies in the package policy. So you want to make sure you're covered. Go ahead, Mike.
The association has a blanket policy for doing minor home repairs and changing light bulbs and screens and doors. I guess want to make sure that's covered. Of course, talk to your insurance broker.
Right.
But typically something like that, my understanding is, would be covered under their liability policy.
Carl
asked, what about if the helping hands are just volunteers? And I believe he's
right. So I'm going to try and interpret that as best I can. What if they're just volunteers? Well, all of us are volunteers, right? So the board members are volunteers, the committee members are volunteers, the club members are volunteers. So I don't think that's going to help us, right? The liability issue will still be there. The financial issues will still be there. The real issue there is get a handle on it, right? Get a handle on it. So if Carl, you're saying, well, it's just a neighbor helping a neighbor. It has nothing to do with clubs. It has nothing to do with anything else. Well, if a neighbor, God forbid, helps a neighbor and the neighbor gets hurt, I have seen cases where one neighbor sues the other neighbor, even though the first neighbor was just trying to do the right thing and trying to help them. But what happens in the world, unfortunately, of lawyers, you know how these lawyers can be, and insurance is, the neighbor who was injured will say, hey, Fran, it's not that I really am going after you. I'm just going after your insurance policy. Well, that doesn't make me feel any better, right? But it happens all the time. I had a family member who was requested by a neighbor to pick someone up at the airport as a favor, and they got hit by another car on the way back from the airport, and the friend sued my family member, and my family member was not excited about that. And the fact that he was, quote, just going after the insurance policy didn't help anybody. So you got to be careful with that. Like I said, the helping hands clubs are awesome. They're great, well-intentioned. You've got to make sure, if you're going to have a helping hands type club, that you are well insured and that you have things formally straightened out. Go ahead, Mike.
Yep. Colleen asked, should we have additional insurance if the maintenance vendor is going into the homes on the association's time?
Should we have additional insurance if a maintenance vendor is going into homes on association's time? So should we have if an association vendor is on the association's time, the association vendor should only be doing association work, right? So they shouldn't be doing side work during the time that they are on the clock for the association. And that's a huge problem with our clients on the Gold Coast, where the super, in the high-rise context, where the super is supposed to be working from 7 a.m. to 3 p.m. Doing all his or her work, and the manager routinely finds him or her fixing stuff in associations units, right? Doing side work and getting paid for it. So that's a mixed question there, Colleen. I would say that's a managing the vendor question. And if an association vendor is doing stuff on his own time for association unit owners, that's fine, but that should hit his policy, right? He or she should have a separate policy. Go ahead with the next one, Mike.
All right, it says, if you list the various clubs on the association's website, does it make it a sponsored club? I'll just make a quick comment about it. So when we do something like that, it bolsters the argument in the event that there's a problem down the road, that the association did in fact sponsor the club, but it will ultimately come down to the nuances. Is it listed specifically as a non-sponsored club that meets in the association's clubhouse, for example? Or does it have the association's name affiliated with it? But it would certainly go into the basket when somebody's making the arguments against the association to pursue the association in the event of a claim or an issue.
Right. Yeah. So Marty, saying the Brick Township Rescue Squad is holding a dance in the association's clubhouse tonight to raise money, you could have a footnote on that says that this is not an association sponsored club. But that sounds very different than saying the Beaver Brook Helping Hands Club will be holding a fundraiser in the clubhouse, right? To highlight what Mike is saying. I mean, people are going to believe that the Beaver Brook Helping Hands Club is an association sponsored club. So you really have to be careful. I would say if you're going to expand on Mike's point, if you're going to put a club event on your website, and it's not an association sponsored club, I would put in there, this is not an association sponsored event. The Hamilton Township Rescue Squad is an independent organization, however you want to put that. Go ahead, Mike.
Not necessarily club activity, but the carriage house building collects medical equipment and the residents can take and reuse them. And then Al kind of follows up on that saying, how about if it's like sanitized and repaired and made available, what additional liability is there to the association?
Right. So you're going to see me jump out the window, right? So this stuff terrifies me. I mean, it's all great. I mean, my parents have a basement full of durable medical equipment, right? From urinals to potties to crutches to all kinds of stuff. I think every guy over 70 has a urinal under the front seat of his car, right? So we got them all over my dad's cars. But the fact of the matter is, you can clean them, you can sterilize them, you can repair them. When push comes to shove, you could be looking at a very, very significant personal injury claim. And my concern with these types of things is it's not worth it. It's not worth it, right? It's a wonderful thing and it makes sense in the real world, but the carriage house holding walkers and then doing a walker exchange is going to get you sued the first time someone falls in that walker. Guarantee it. And the problem with that is that the injuries can be very, very significant, right? Better to have them rent the walker or rent the wheelchair from a durable medical equipment rental place, even if they don't purchase it. It's just, I believe, and this is, it's not a legal prohibition. It's just as a practical matter, the risk is so high. Go ahead, Mike.
All right. Cheryl asks about a club that's operating outside of the charter that presents any additional liability to the association.
Yeah. So Cheryl, they need to be reined in. So if it's an association-sponsored club, they're operating outside of what they've agreed to operate in, they need to be reined in. They need to be brought into an executive board meeting and have a conversation of what are we missing? Do we not understand what you really intend to do here? Do we need to revise your club charter? Are you just going rogue on us? Because if you're just going rogue on us, then maybe we need to shut down the club and you need to do something different. But they should be operating inside the charter or their charter should be changed. Carl said he had to go. That's fine. Thanks, Carl. See you.
And Frank asked, do the association clubs have priority over independent clubs when establishing calendar events?
The associations have priority over independent clubs and stuff. So I think that's a decision for the board. I think that's a board decision. I think from a politics standpoint, association members will very much say we should get priority, right? But from a practical standpoint, I don't think there's a legal prohibition on doing it. And I think the board has the discretion to make a judgment call. But it's more a political thing. We have another one. We are told any job has to be called into an answering service in order for us to fall under the association's blanket insurance. We are told any job has to be called into the association's answering service for us to fall into the association's blanket insurance. Al, I don't really know where you're coming from on that. I think what you're probably talking about is if there's a work ticket generated for work inside an association unit owner's unit. The association's employee who comes in to do the work, I think it's more of we know about it, right? This goes back to Colleen's question. If there's a, in your case, Al, I believe it's employees. In Colleen's example, it's an independent vendor. But if a vendor or an employee goes in to do work inside a unit or a home, the call-in provides evidence as when the employee was there or the request that the employee was there. You see what I'm saying? If a call-in was not made and an association employee or an association vendor came in, there's still going to be a debate, as Mike said, over whether or not that person was there in an authorized fashion, whether he was taking it upon himself, was he doing it as side work after hours, those types of things. And usually they wind up in arguments between insurance companies, the association's insurance company or the HVAC contractor's insurance company and or the employee himself. Was there another one, Mike, there?
Yeah, when a club is collecting a fee for an event and promotes a 50-50 or lottery, should the money collected from the lottery be reported separately?
I'm going to refer that to my friend Mohammed or whatever auditor you use. I suspect the answer is yes. And I believe that the Games of Chance Commission requires a report after the event itself. So that's not a tax issue. It's also a compliance issue with the state. So I believe Games of Chance require reporting after each event. And even in bingo situations, I believe after every bingo night, there is detailed reporting required in terms of the number of games played, the amount of money awarded, the number of prizes given, etc. So I think the answer is yes, but I am going to refer that to your auditor.
And then Fran, Al was just clarifying here. So he was saying that the residents, what he was talking about was the residents are required to call the Helping Hands hotline directly and not the volunteers themselves in order for it to fall under the association's policy.
Okay. You know, Al, I'd have to have more information on that, Al. I'm not so sure at the moment. I mean, if we want to talk about it more offline, we can. Apparently, Terry Vigiano has her hand up and wants to talk. That may be a first for this entire First Friday with Fran.
Well, I'm sorry, Franny. I was a little late to the game here today, but
Okay.
What the hell was my question? Oh, we recently had a situation where we asked our insurance company if a club would be covered under general liability, and the answer was yes. That they're part of the association. They're not some rogue club from off the property. So the answer was yes. Just to let you know that information.
Right. So and we talked about this a little bit before. So this goes with lawyers and insurance people and everything else. The answer is always yes, but. Right. Yes, but. So the yes, but there is, and we talked about lots of things in the association club context that are not covered. So many off-site activities, bus trips may not be covered, fishing trips may not be covered, travel to Europe on an airplane may not be covered. So very careful about that. We talked about pickleball a little bit. Organized sports leagues may not be covered. Activities in organized sports leagues. So you got to be very careful. So what I said, I think before you joined, Terry, was that each club activity should be run by the insurance professional.
Right.
Because you may wind up with an endorsement or an additional policy, freestanding policy. But thanks, Terry. That's good.
Thank you.
I think we're out. I think Helping Hands, we got that. Thank you for the topic and shut out the thing. Okay. Well, thanks so much, everybody. It's great to see everyone. Hi, Chip. Hi, Roz. Nice to see you. Hey, Tara. It's good to see everyone. Thanks again. Have a great month, and we'll see you in August. All right. Stay out of the heat. Stay cool. See
Take
you
care.
later.